Hello everyone, and welcome to our discussions at ASBSD. I'm Wade Pogany, Executive Director, and we want to welcome you to this visit. We're going to talk today about what constitutes a legal or an illegal meeting for school board members. And joining me today are Gerry Kaufman, who is the Director of Policy Services, and also Dr. Randy Royer. Randy is the Director of Board Development. Gentlemen, thank you for joining me today.
Glad to.
And so let's have a visit about board meetings and what the law says about making them official meetings and when we can meet, when we can't meet. So, Gerry, let me start with you. What constitutes an official meeting? What has to happen in that event so that it makes it official?
Under an Attorney General opinion, there's two criteria or elements for what constitutes an official meeting. Majority of governing board members, same time, same place. And the second element is talking school business, talking shop, something that's related specifically to that school district. Those two elements are being met. That would constitute an official meeting, which would then require the posting of notice of meeting within a proposed agenda.
Okay, so we just have to make sure that whenever we're in any situation, not necessarily at a board meeting, we've got a quorum of people and we're talking about official business.
Correct.
So that really constitutes a meeting. That's important to note. So what should board members do if a quorum of people happen to be at a ball game or a concert or an event? You know, they go, they're socializing with each other, but it just happens to be that they're all there. And so what advice would you give board members about being in that situation?
Well, one, don't discuss school business and try to avoid the quorum. So those two conditions are not met.
So if it's a 5-member board and you've got 3 together, you've got a quorum.
You have a quorum.
Yeah.
Well, you have a quorum if official business is being discussed. But from the public's perception, if you have 3 out of 5 governing board members at the same time, like we're talking at a concert or basketball game, and they're standing alone together, there is a perception that can be given, and that is what has to be a concern. So either you don't have a quorum together, or else you invite somebody else to hear what the discussion is and to help you police yourself so you're not talking shop.
So it's just best to not put yourself in that situation, really, then to avoid that if you can.
Correct.
It's okay to go to the ball game and support the kids, but
Sure, absolutely.
But you have to be careful about that. So the same thing in a different realm, though. What's your advice on the best practice for board members when it comes to emails? You know, we may not be in the same place at the same time, but what if we're having a discussion about buying the bus and we're on email? Is that okay? Is that acceptable in open meeting laws?
You want to go first? That's right.
Well, that hasn't been officially recognized in South Dakota yet. Other states have recognized that that is an illegal meeting. When you reply all and you get a quorum of the board discussing something via email or other electronic means. So first of all, don't reply all. You can use email to schedule or share information, but when you start discussing and saying, well, we should vote for this or we should do that, and you reply all and you have a quorum of the board members replying and having this email discussion, that could be construed as a possible illegal meeting.
So what would the problem be if we're just trying to solve a problem, but we're having a discussion in email? Why is that a concern?
The problem is, and it's really not a problem, it's inconsistent with the open meetings law and the philosophy behind the open meetings law to begin with, where governmental business is to be done open to the government except for legally executive session purposes and things of that nature. And an email correspondence or a phone tree correspondence, the whole concept of consensus building so a decision is made before an official meeting, official school board meeting, is very inconsistent with that meeting and with the open meetings law. And realistically, if that kind of consensus building is done and it becomes known, it can result in a violation of Open Meetings Commission, a reprimand. It can result in the decision being voided by the court, as well as criminal offense. There are serious consequences to governing board members and a governing board that do not operate within SDCL Chapter 125, the open meetings laws.
So if a board member wanted to schedule a meeting with someone, they could do that, but just don't have that discussion on Facebook or email or any kind of situation in a telephonic sort of
Correct.
fashion. Okay. What happens, or what should board members do if they want to attend a meeting or a conference maybe outside of their district, and they're going to try to save some money and they're going to travel together? You know, they're all in the car together, and they're going to a meeting. Maybe it's an ASBSD region meeting, but there's a quorum there. And so what advice would you give them about getting in that car?
Don't.
Don't.
If you have a quorum and you're going to discuss school business, that's a meeting. So either don't have a quorum, or if you have a quorum, and it makes sense if 5 members of the board are going to travel together, save some money, don't discuss school business.
Mm-hmm. Okay.
But again, it's that perception. What does the public see? Well, they see a quorum of the board riding together. They assume you're going to discuss school issues.
Right. So what I'm learning is it's just best that if we're going to make any kind of discussion or decisions about the people's business, we should do it in an open forum where there is a quorum and it's the protocols are there, and then you'll be fine.
Definitely.
Okay. Great. Well, thanks for joining us, everybody, and have a good day.